Allow me to introduce our panel. Today we have four good speakers we're happy to have with us. First is Liz Skane, who's one of the founding partners of Skane Wilcox. Their firm has offices in San Diego, LA, San Fran, and Las Vegas. Liz earned her undergraduate degree from Georgetown and her law degree from USD. She's been in practice here since 1996 and specializes in construction defect litigation, including premises liability, as well as government tort liability and general insurance coverage cases as well. Liz regularly represents contractors and subcontractors, and I'm sure she's familiar with many of you in the room. Liz is a member of the San Diego County Bar Association, the Nevada Trial Lawyers Association, the Association of Southern California Defense Counsel, and any number of other organizations. Liz also served on the 2005 San Diego Superior Court Committee that put together the Forum CMO, and she's currently co-chair of the Construction Defect Committee for Claims and Litigation Management. Over here is Fred Gordon. Mr. Gordon is founding partner of the well-known San Diego firm Gordon & Holmes. He's a 1977 graduate of UCSD and a 1981 graduate of Cal Western. Mr. Gordon was admitted to the bar in 1981 and spent the first 5 years of his career as a prosecutor and then as a criminal defense lawyer. Mr. Gordon's current practice focuses on complex business litigation, foodborne illness matters, intellectual property, and real estate disputes, as well as some construction defect litigation. We invited Mr. Gordon to speak here because he's had some experience in plaintiff CD cases. In his career, he's tried in excess of 60 cases to a jury and over 100 non-jury trials, including a variety of cases with 8- and 9-figure damage numbers. Mr. Gordon's a member of the state and San Diego County Bar Associations, the Association of Trial Lawyers of America, California Trial Lawyers Association. He's a program lecturer for the Consumer Attorneys of California and the Mormon Educational Series. And we have Mr. Baumgartner, Ted Baumgartner. He is president of Expera Group, a Solana Beach-based construction consulting firm. Mr. Baumgartner holds a degree in architectural engineering from the University of Texas at Austin. He has over 35 years of experience as a general contractor and construction manager. Before Ted founded Expera, he was the principal and the license holder at GAFCON, a construction management company that was ranked in the top, was ranked in the top 50 of construction management firms.
They're still
top 50 in the nation in construction management firms. As a professor at San Diego State University, Ted has taught a graduate level course in construction management as part of their master's program in civil engineering. Over the past 20 years, Mr. Baumgartner has been designated in some 600 construction defect cases as an expert in the standard of care for construction management, for cost of repair, delay analysis, and property loss claims. He's past president of the San Diego chapter of the Forensic Expert Witness Association and has been on the National Board of Directors of that organization as well. And finally, we have Eric Thorsness, one of the owners of Thorsness Litigation Services. As you all know, it's a San Diego-based court reporting and trial presentation firm. The firm consists of former litigators, litigation support specialists, and court reporting personnel. Eric began his career as a paralegal at Thorsness Bartolotta in McGuire, where he put to use the very first application of trial director. Eric has since personally handled a variety of matters for our firm. I work at West Montana's. And I can attest to the value of his involvement. He now handles virtually all forms of in-house litigation support software. His firm emphasizes, I think, and focuses on the use of cutting-edge technology and trial support. And his engagement stretch across the country, not just here in San Diego. Our speakers have sort of an informal agenda to go over for about 40 or 45 minutes, and we'll conclude with 10 minutes or so of Q&A. But we're obviously in an informal environment, so if you have a question, feel free to just raise your hand and sort of ask them what you like. With that, I'll leave it to you guys to entertain us with stories.
Hi, like Dave said, my name's Fred Gordon. What they asked me to come because to give you more of a plaintiff's perspective, I guess, on how plaintiffs, at least this plaintiff's attorney, uses technology in trial. Like Dave said, Eric and I used to work together at Thorsness Bartolotta, and we were on a case in the early 90s called Foodmaker, that a lot of people know as Jack in the Box. And in that case, we did 600 days of videotape deposition. And I must admit, we started at that firm doing videotape depositions in the 80s and have kind of evolved in how to use them. And in my practice, I use them in every single case that we do. And I know that for defense lawyers, it's a luxury that they don't have. And it's a weapon that plaintiffs' lawyers get to use against you because you don't have it and because the likelihood is you won't see it very often. When you're when you're starting out in a case, at least from plaintiff's perspectives, I start thinking about setting up questions for the people that you're defending on how they're going to look on a videotape. And so, and then what I do is break it down. And Eric's going to tell you the more advanced way to do it because I'm still a lot older than him, so I do it the old way. But what I do, literally, and I'll show you people, I get a depo at the end of the day. You know, everybody gets their depo transcript, right? So when I'm taking my depo, I have in my brain, okay, I need a question answer. I need a question answer. So I might ask the question, tell me everything you know about X. And they'll go on for 5 minutes. And then I say, this is the thing you don't want to hear me doing. Let me see if I understand. Is it this? Yes. Is it this? Yes. Is it this? Yes. And so, because the reason I'm doing that is because I set up my outline like this, and see these little barcodes? Okay, so I barcode all the question answers that I'm going to use in my examination. And I do my entire examination like that, so that if you say something even slightly different, and I like how it was said in the depo better, I'll pull it up. Interesting about that is because you can say, okay, what does that have to do with it? Well, watch how he's looking. He's not looking at the camera. And he's not dressed like he was going to dress in trial. Okay? If you get a notice with a videotape deposition, you better have your person dressed like they are in trial. Because if he comes now in a suit and a tie, the jury is going to think differently of him when they see a videotape that he's not in a suit and tie. The use of videotape is as much of, if not more, of what you see versus what you hear. Because there'll be times where we use it, and I call this zapping. And actually, Gene even turned off the sound, because when I hit one of my barcodes, and this is why I still like to use it, it's as much of a show that I'm putting on for the jury, because it's my belief that in today's world of jury trials, more and more of your jurors are going to be used to smaller and smaller sound bites. And if you have sound bites mixed in with a show, that will be more persuasive than if you just drone on, if you pull out a deposition when you're trying to impeach somebody and you say, let me read from your deposition. You remember having your deposition taken. What I call the real old school. I'm kind of old school just by doing this. Like I said, Eric's going to show you more. But what I do is if you get somebody, and one of the things Ted always talks about is, I actually even change the questions. Because it ends up being that you have like soundbite words in your answer. And the answer may sound fine. And we've talked about this where Ted goes, I didn't say anything that you weren't saying. But I acted like he was. I acted like he was. And what I did is I could change the question. And you know, if you're parties, you can use the depos for any purposes, and you can end up changing the question. And then as long as that key word in your new question is in the answer, and it's slightly different, they'll think that you impeached him. Gene turned my sound off, but I like the sound because it's like a Pavlov dog.
It's a cue.
It's a cue for the jurors. Something's going to happen, and so I'll go like this, and they'll hear that, and it'll pop up. You know, and see here, no, the reason I wanted to show that one clip is because the lawyer was not telling Ted, pull your hand down. Okay, because that's what the jury's going to see. If a witness goes like this, if a witness looks up to the sky when they're answering a question, you know what? That means they're looking to God for help. It does. You got to train your witnesses. When they're asked a question that's not good for you, don't go like this. Because I'll play it just for that reaction. Or make sure they don't pick their nose. Because I'll play it just to show them that. You weave these things in because a trial is a lot more than just who's got the right evidence and I should win because I'm right. Okay, that's not what trials are about. Trials are how do you present your evidence in your best light and how do you denigrate your opponent's evidence in their worst light. So those are the things that we use, but from my perspective, you got to have an understanding that if you're up against plaintiffs' lawyers who've tried a bunch of cases, that the likelihood is that they are, or maybe they themselves, because quite frankly, I'm not technologically oriented, but I have people who help me, and so now I've learned how to think in presentation mode, because that's all it is. It's a show, and so if you, I mean, like he's really advanced, but if you got to think that there's going to be people like me from day one, and this is how we think, and this is because we don't come in and the thing that I want to say before I stop was the most important thing you guys can do, which I don't even know if you guys ever have the luxury of it, is like when I get a case, the first person I hire, if I had a construction case, I hire Ted the day I get the case. And what I see from a lot of defense lawyers is that they don't have that luxury. And they go through the case because the carriers don't want to pay for all this stuff. And then what happens is they get somebody at the end because they said, well, he's just the construction guy. He's just going to come in and say, this is what it is. And there's no, they didn't do anything wrong and boom, boom, boom. Well, if he doesn't know my theory of the case, he doesn't know the questions I'm going to ask him at depo that might seem completely innocuous to him because he doesn't know where I'm going. So this is kind of that's how the depos get translated, because I used him to further denigrate the clients who had already been on the stand and been impeached a bunch. And that's how, by the time we got to him, that's why they knew if I was pulling out my little gun, something big was going to happen.
So if you actually get to trial, I think that trial technology can be really, really helpful in visually showing plans and specifications coupled with pictures to show that while maybe the issues are complicated, like again I'm going back to a case I tried with Jenny Jacine, we represented a deck installer on a $9 million single-family custom home in Orange County, and the deck leaked like a sieve. And everybody told us in advance of the trial is, you might as well pay because you represent the deck guy, right? The deck leaks, you're going to get hit with something. But the water intrusion wasn't coming from the deck, and we actually tried that case and we defensed it. This is actually a different one that I was just talking about, but this is a fire loss case that Kent and I tried. It was actually, it wasn't quite a construction defect case, but in that case, one of the issues was the plaintiffs claimed a $400,000 cost of repair that they were seeking from our client. And the fire was really limited to a very narrow portion of the building. And so we, through the use of exhibits and some pictures, were able to show the flow of how the fire progressed to show that, listen, even though they say all these areas were damaged by fire, they weren't really. So, okay. So what we did is we got in through an exhibit, and you see it, we labeled it at the bottom, again, talking about preparation. We got in this exhibit through other witnesses, and then we were able to use it with our expert, and we were able to show that the cooking area, the cooking area, which was an issue of whether or not there was adequate fire protection, was a very different area than the fire area. We were able to go through and show how the fire, because what it was a vent that sucked up some grease and sucked it up into a certain area, and we were able to show, again, that was the vent pipe, we were able to show where the fire began and where it progressed. And able to show that, listen, this is where the damage was, and then we were able to get in through pictures. We were saying, listen, look, here's a fluorescent light fixture right near where the fire occurred. And look, it's not even melted, right? So when you're showing these pictures, you know, when you're going through witnesses, they can talk about it, but it's a lot more effective when you can say, okay, here's the fire, and you can show right adjacent to it is where this light fixture was. Okay, then you can say that there's some plastic containers, and obviously you will have had to set this all up through other witnesses in advance. Again, so it's all about planning and preparation. So you got these other plastic containers, and they aren't melted either. So, you know, you can see how when you're using trial technology, you can integrate multiple factors and really show them. In this instance, we were trying to show, listen, this wasn't the massive fire that burned everything, causing the whole building to need to be, you know, rebuilt. This is a very limited issue. Again, there's a plastic jug right there, filled with grease, by the way. That's not burned either. There's more plastic containers. Look at those. Those aren't melted either. So this is just one example. Again, plastic screen that was up. This was a restaurant. That plastic screen, that's not damaged either. And keep in mind that they were claiming in this case that the fire basically damaged the entire building.
So Liz, do you create this in-house, or do you work with your expert, or how do you come to the thought, really, that this is how you want to present this issue?
Well, in this case, it was Kent came up with a lot of this stuff too, but Kent's one of the attorneys in my office. But what we did is we worked both with the expert witness and we worked with a person like Eric to put it together. I don't have the ability to do this. This is actually put together in Keynote, but again, there are other programs that do it, as you know. Yeah. And then we talked about the unaffected beams. But the one thing that also I want to point out is, obviously, you know, as defense lawyers, we're always looking to contain cost. When you actually start putting together this kind of stuff, the time and energy and whatever can be very, very expensive. So you have to, you know, analyze, and you have to work with the insurance carrier or whether it's with your client in estimating and deciding whether or not the cost or the end result of the case will actually make a difference. So you have to appropriately kind of decide. Now, this case was a pretty big case. There were punitive damages. There was a policy limits demand in that case, but it's not true in every case. There are other ways to use technology that are a lot more simple. And another thing that we like to do in the cases that we try, which is very, very simple, doesn't take expert witness, but there's just a way to really, you know, grab the jury and grab their attention and move with it is, for example, in closing arguments. And I think that those of you who've done trials have probably also seen, you know, people, what they do is they'll get out the jury verdict form and they'll slap it on an Elmo. That's a way to do it. Elmos are cheap, you know, I mean, that can be very effective too. I've seen people like Fred Gordon do it. I've done, Jenny and I did a case with Bob Francavilla. You probably know him. But he did it very effectively. He took a jury verdict form that had been approved by the judge. And this is simple. This doesn't cost any money, but it takes the attention of the jury. And he got the form out, say this is the jury verdict form, and he reads the questions, and in his closing argument he says, okay, so for question number 1, you know, was the defendant negligent? And he writes a big X. No. And then he stuck it on the Elmo and he showed it for everybody to see. That's simple. That doesn't take any time or effort. It takes you, you know, it takes 5 minutes. It takes the equipment to be there. What we've done in some cases is, what I like to do is to actually type it into a program and tell the jury, see if I can find it here. Here we go. Oops, this is a little bit different. But take the jury verdict form and put it on a Keynote and type in the special verdict form, which, by the way, you also, in order to use it, the judge has to have had it approved to begin with, so you've got to get that taken care of during trial. But you fill out the form for them. This is not something that's particularly complicated, but when it's the last thing the jury sees when they go back to the jury room, and you're just saying, hey, listen, you know, let me make it easy for you. This is how it needs to be filled out. What are the plaintiff's damages? 0. And then you can interweave documents that are just dumped into into the program. So I can show, so in this instance, we used additional documents, again, exhibits that had been labeled in advance and admitted into evidence to show them why, remind them why they need to give a 0, and without getting into the facts, these are all documents to support why we say there needs to be a 0 verdict. See, this stuff is also very easy. I mean, I like the way it drops down. I think that's cool. But, why there needs to be 0 awarded in those areas. And then, you're able to interweave, again, reminding them and telling them exactly how to, again, find. This is straight from the jury verdict form. So this kind of stuff is very, very simple, but it can be very compelling. I think they've done studies that I've read that shows that when you take a combination of demonstrative evidence with oral testimony, the juries remember and absorb it a lot more. So that's one of the reasons why this stuff is very compelling. I didn't know if you wanted to add anything to that.
No. I mean, I think that the more varied you can be in any trial using multiple types of presentation modes or demonstrative modes, the better off you are. I always bring an Elmo because I don't want to always be wedded to the computer, because I've been in cases where if everything is computerized on both sides, the jurors get bored as well, because it's just too technologically advanced for them. But when you can mix it all up, and I mean, I still use big boards when I write on them sometimes, just to make sure that you're keeping it lively, because all of these techniques that you use, I mean, from my perspective, it's really about just trials. You got to keep people interested. One of the reasons I use the videotape depots all the time is because I'm of the belief that current juries, not all of them, but most of them, if something's said on the witness stand and then something's said on a videotape, they'll believe the videotape. They'll think that you're lying on the witness stand, because everyone is so programmed now to Facebook or just short bits of information, and that is more consistent with how they process and how most people process information now. And the younger the jurors you get, the quicker and the shorter pieces of information they're going to process, and they're going to appreciate that short clip, which is why, I mean, I'd never seen the little drop down. I thought that was awesome, because, or the turning of the page, because anytime you can make the jurors focus, that's the name of the game, is getting them to focus, not making, I mean, I agree, getting your evidence in is very important, but you have to have these people focused on what you're doing and what you want them to hear. And by utilizing various types of technology, you can maintain their focus on what you want them to do. And so, I mean, I'm very impressed. I like this stuff.
The other thing I want to say too is, and Fred was making a good point earlier, is as defense lawyers, we don't often videotape depositions. We certainly don't do it in construction defect litigation. We get approval to do it more often with crazy plaintiffs and bodily injury litigation, which can be really fun. But you can use deposition transcript. You don't have to necessarily do it just the old school way, to say get up and read. Now if you're unprepared and you don't have it prepared ahead of time, then you got to get up and read. But what we've managed to use very effectively, and you can do that by working with someone like Eric or someone else in his company, you upload all the deposition transcripts to trial director or visionary or something like that, and if you know it's coming, or you set it up in your own questioning, you can actually show that deposition transcript. So if you set up the question appropriately, right, and they answer it the wrong way, well, don't necessarily read the impeachment testimony. Put it up on the screen, which is what we do all the time. Let's 1 second, right? So in this case, this was an example of a party. Again, party deposition can be used for any purpose in this case. And we asked him, at trial, it was an insurance broker case, and we asked him, did you ever sit down with our client and talk to him about what insurance coverages you really wanted? And he said, no, I never did that. You never sat down with Michelle Tapia, affiliated with my client, and you didn't ask her what coverages you wanted, and you didn't have her explain? No, I didn't do that. Well, then I didn't have to read it. I read it. You can put it right up on the screen. And that is so much more compelling than just reading it into testimony, because you know what? They may or may not be paying attention to what you're saying, but they're sure as hell paying attention to what you put on the screen. And in this case, we again then sat down and said, you know, asked more questions, and then, let's see, again to the issue of what we asked. And again, we said, and you got to set up the questions exactly. When you're doing impeachment testimony, you say something like, in this case, the question was, didn't Michelle Tapia sit down with you and explain to you in Spanish, these were Spanish speakers, the coverages under your policy between 2002 and 2006? Didn't she do that? And of course, at trial, she said no. And then, of course, like Fred says, you can get up there and you start fiddling with your computer, and then the whole jury sits up and goes, oh, there's something good coming now.
I'm going to share with you some technology we've developed for mediation and can be used in trial. I just want to say one thing, kind of segueing back to the discussions that we've had here regarding this whole videotape thing and what have you. And it's the importance of assignment. If there's any one thing that you can do to help your expert do a good job, it is understand the assignment and make sure the expert's on page with the right assignment relative to all the issues of the case. Because as an expert, we don't see all that other testimony. We don't see all of what's gone before. We come in and do our thing according to our assignment. But if it's the wrong assignment or if it's different than what's needed, we're limited on what we can do for you. I want to share with you a little something we've developed and used pretty frequently. In fact, this is a case, I think I see some folks here from the Lorber firm. This is something we developed for you, and this is a case we had for you folks. All right, technology. Here's the thing. We all use PowerPoints a lot and what have you. However, PowerPoints are linear. Mediation and trial can be somewhat linear. I mean, your presentation could be somewhat linear. Mediation certainly isn't linear. Mediation is a non-linear process. It can go in any different direction depending upon what goes down at the moment and who's there today and who show up with their carrier here with them or not or whatever. Mediation is a non-linear process. So we developed an approach specifically for mediation. It could be used at trial though. And here's how it works. It's a presentation built like a website, kind of like that. It interacts like that. So the Geico case, a very large case involving the Geico headquarters. Let me go back to, this is the building here. It involves the Geico regional headquarters out in Poway, and we were in as defense for the general contractor. Okay. So we were asked to put together a approach where we actually pulled together a whole team, contractors. We came to the table at mediation not just to say here's what our opinion is, but present a bid to do the work, guaranteed, bonded, insured, ready to start on Monday. Here's what we'll do and here's what we'll do it for approach. And so we prepared this presentation, and so we first started out with an introduction to the team, and you kind of see the way this thing works. I can go anywhere I want to, and if I want to pull up and talk about this particular party, this contractor who is going to be the general contractor, I can go into it. If someone says, oh, what about X project that they did, I can pull that right up. I can go, it's completely non-linear. It acts like a website. I can go any direction I want to go, pulling up information to suit my purpose at the time. And then we can take them on into the reconstruction plan. And this got a little goofed up with the text there. But basically, we presented a curtain wall repair plan. We could go in and bring up a specific zone of that plan, describe what we're getting ready to do, pull up photographs to put you back at the project, We could be describing how our approach was going to be. This particular project, it was a complete curtain wall replacement, and we had very differing opinions from plaintiff on what it was going to be required in order to isolate the work to avoid disruption and loss of use. So we were able to have this discussion, pulling up photographs showing the curtain wall system, etc., and demonstrating what we were talking about in a very nonlinear fashion that proved to be fairly effective. For the mechanical, a lot of this was mechanical repairs to the air conditioning systems and what have you. We could pull it up and go to any particular area to talk about the particular work. Pull up a specific repair. This oval duct we're talking about, well, it looks kind of like that. We can kind of pull it up on the fly, go back, discuss it, pull up details of how the bracing was going to occur. And the cool thing is you can go into it with this type of presentation, you can go into it as deep as you want to or not. You know, you can go focus on the areas that are important to the discussion at the time and go in any direction that you want to go in. We come up with a specific phasing plan. We could go into how we were going to execute the work, pull up any specific phase in detail, and all this color coding meant something with respect to the temporary barriers and what have you. Anyway, as a what that message for, but anyway, so I've used this. It's taken on all sorts of shapes. I've embedded video before. I have even put in links to where it links you back to websites that are live and pull up information directly from websites. It's just completely up to your imagination on what all can go into it. The beautiful part, though, is this. Here's the beautiful part. All right. So we're getting ready to go to mediation. And as an expert, just like any presentation, you're getting ready to go to mediation. I'm sitting there getting ready to start, and the attorney's whispering in my ear, "Hey, Ted, so-and-so didn't show up with their carrier today, so skip that part, skip that part. But these other folks are here, so focus on them, focus on this part. And oh, while you're at it, take them through this other part here." Well, I can do that on the fly. If I'd have built a PowerPoint, I'd have been, having ulcers at that point in time because my whole presentation just changed. But with this kind of a tool, it doesn't matter. I'm ready to go any direction you want to go, and we can even change it on the fly. So that's ended up being a pretty effective tool. One other thing I would say about trial exhibits is we brought a few toys with us here, this stuff out of our warehouse that we built for various presentations and trial exhibits. Okay, as an expert, your job is going in the courtroom and making complicated technical stuff really, really simple for juries that don't know this technical stuff, right? So it really helps a lot of times when we can bring, you can't take them to the project, but you can bring a piece of the project to them. So we build these mock-ups, and feel free to look at this stuff when you're done. One thing that works well for us is we've built enough of them over the years that when we need one, chances are we may not have to go start from scratch. We can just buff out one of those we did 5 years ago and dust it off. Things like describing to a jury a soldier pile shoring system. What the heck's that? What's lagging? What's soldier piles? I mean, it's hard to describe that, even when you show them plans and stuff. But if you show them something like this, you can show them exactly what are the soldier piles, what is the lagging. Technical terms, rat slab, which is a slab that's poured underneath a waterproofing membrane before the final finished finished slab on grade. You can show them how that fits in there. You knew that. You knew that. So this stuff just lets, and like everybody's been talking about, the key with jurors is I think media has shrunk our attention spans to a very small thing, right? So all this stuff, it's entertainment. These people, they need to be entertained, and this stuff is entertaining.
You've heard Liz and Fred mention several times getting a hold of someone like me, and to the extent you think you're going to be doing any type of presentation at the time of trial, the sooner you get a hold of me, the better. There's I mean, even when you bring the case in-house, so we can talk about the best way to mark your documents for production, date stamping, file types, working all that stuff out in advance. Zapping?
Can hear you.
Yeah.
Zapping.
Yeah, if you want to zap, we'll give you barcodes and you can zap. But the earlier the better. I mean, you can spend an hour on the phone, or I can spend an hour down at your office working with you and your staff, making sure it all goes out with this in mind at the end, whether the case actually goes or not. So.
Well, one of the benefits, I think, of using somebody like Eric as well is because he's had, well, he's grown up in the law. and so what that means is that he's interacted with a variety of different lawyers. Every trial lawyer, every good trial lawyer I know has their own style. And if they just copy somebody, then they're not a very good trial lawyer. And so he has the benefit, which obviously he can pass on to you when he's giving you ideas on how to present something. He's got the benefit of a lot of different trial attorneys, and he's seen, each of us have our own, style and tricks of the trade, whatever. And he can sit there and say, well, I know this case. Here's how we did it in that case. Or here's how we did it in this other case, and you can decide which way is the best. So he gives you a lot of, he gives you a great viewpoint on how to present something.
This PowerPoint was put together by an expert on a CD case that ultimately settled on the eve of trial, or about a week before. But they called me and said, hey, we want to do this. Can we do these things? And I said, yeah, it makes sense what you want to do. But they had already started. They didn't tell me that part. They had spent a couple of months working on it. And so they sent over a draft, and I'm looking at it, and I said, where's the exhibit numbers? How are we getting back? What's going to happen? And when they first sent it, nothing was branded. And there's 15,000 photographs in this case. It was an 800 case that was getting ready to go down in the Imperial Valley. So they had to go back, and they didn't track them when they produced them that way, which turned into a nightmare. But this was a fun one. It's somewhat interactive PowerPoint that, as we go through it, each of the issues that they found, you can click on it, and it'll start showing you what's going on. You can click down here, and you can get back to the code. You can go back and look at photographs by individual home, and keep moving backwards till you get to each individual issue. So this is it's an interactive PowerPoint. It's not quite what TED has. It's a little different, but it can be done in PowerPoint without any special coding. But this is something that takes time, and if they had called me in advance, we would have worked through all these things. So these experts, they had to go back and burn about 100 hours worth of time, which was a nightmare. And when I explained why, and they sat down with their counsel, and their counsel thought through it, they had to approve the time. There was no way to get out of it.
Can I add something to that?
Sure.
Just talking again about people like Eric. In CD cases, I think for cases that are CD cases that are tried, we almost always use someone like Eric. You've got multiple parties, because you're talking about, again, as he said, 15,000 photos. You might be talking about 100,000 different documents. And what you do in a case like this is you give him all the documents. He scans them in, and what we've done in the past is a hard drive is created for and those exhibits are labeled, and a hard drive is then used and passed out to each and every different party. But it's nice because then we can use someone like Eric during trial too, using the screens and the computers, and he flips between computers. And then the other thing we'll use someone like Eric for during trial is, as we're prepping direct and cross-examination of our own witnesses, what I typically do is I'll send my outline to someone like Eric or whoever from his company ahead of time. Some people don't necessarily like to do that. They're afraid he's going to share it with someone else. But my experience has been they generally don't, because they know they'll never get hired again if they do.
By anybody.
By anybody. Yeah. But you give them your outline, along with those exhibits that you're looking to use. And then you set it up in the order that you're going to use it, and so that they'll prep. I mean, these guys will stay up till 2, 3 o'clock in the morning. They'll give you your cell phone. You can call them at 4 a.m. and they're usually available and take your call to say, oh shit, I forgot these 3 exhibits and I need you to get them in there. for you start, right?
That's a very regular occurrence,
Yeah.
absolutely.
So then, well, because that's the reality, you know, you're not sleeping. And you got it all set up along with your exhibits so that during trial, 'cause it's all about flow, you want to make sure that it's, the more prepared, the better. So that you're ready, and as you're going through the testimony, you can say, okay, can you put up whatever exhibit, and they've got it already in line and ready for you to go, and then it just goes so much more smoothly.
Right. The amount of preparation can be as little as a few hours. I just put a case together over a weekend for someone that was going out to trial. Actually, tomorrow in Maui, he only had 100 exhibits. It was simple, and he operates it himself. Or I've got a patent case that we spent 3 months putting the database together, and there's several million pages and over 100 videotape depots that we're creating impeachment clips and then video in lieu of live testimony where we've got people that are out of the country and we know won't be showing up. So, you know, it runs the gamut time-wise. Yeah. And one of the, if you're building a PowerPoint or a Keynote or using Ted's program, when you're using the photographs, that was one of the big issues on that PowerPoint that I showed you. They didn't mark the exhibit numbers on any of the photographs when they were going to display them. They were going to list them out just by the address. And I said, how are you going to get the jurors to remember what they're looking at? And how is the expert going to remember? Does he have some type of book up there that he's got an index going back to all these photographs? So when you've got a great photograph and you want to make sure they're remembering it, you know the photograph itself will be admitted, but the PowerPoint won't. Make sure everything's labeled with an exhibit number somewhere on that slide, so you can, as you're talking to the jury, you can say, and this is exhibit number 619. And hopefully they take that note, because they can look at that photograph again in more detail when they get back to the room.